Good evening, everyone. Welcome to the Jersey City Rent Leveling Board meeting tonight. Having been properly advised, in accordance with the sunshine laws of the state of New Jersey, today, June the 12th, meeting of the Jersey City Rent Leveling Board is called to order at 6:10. I'm sorry, 6:05. I'm 5 minutes a little early. All right, 6:05. Roll call, please.
No problem. All right, we're going to do the roll call. Please confirm by saying aye if you're here. Alexander Hamilton,
Aye.
Danon Hill,
Aye.
James Eacock,
Aye.
Joe M. Williams, Mark Issakoff,
Aye.
Michael T. Brown,
Aye.
Solomon C. Johnson. Aye. All right, we do have quorum.
There being a quorum, the meeting will proceed. Thank you for attending our meeting tonight. Everyone will have an opportunity to speak. Please speak only when recognized by the chair to speak. Address the board and not your adversary. Keep your presentation to the issues in question. The board will listen to all sides of your complaint or application and come to a decision. All parties will receive the written decision within 3 weeks. You will then have 45 days to appeal the decision to the Superior Court. So if you do not like our decision tonight, please be civil and appeal it when you receive it in writing. I count on your cooperation tonight. Any calls, cancellations?
There we go. No, there were no adjournment requests for this evening, Chairman.
Okay. Before we get started, all parties on both sides, tenants and council, please hold your rebuttals or your responses to 3 minutes as you present your case, not to be here 5 or 20 minutes. We need 3 minutes of your time. That's it. Express yourself, and we go from there. All right? First case is a legal rent petition, 108 Sussex Avenue. Landlord Quality Prospect. Good evening. Speaking to the mic, sir.
Oh, there we go. That's better. Neil Murata on behalf of the tenants appellants.
All right.
Okay. All right, so we are here tonight on a petition, rent determination petition filed by the tenants. I'm sorry, is that better?
Yeah, better.
Okay. The time won't count against me, right? Only kidding. Okay, so we're here on behalf of the tenants. Tenants' position is that this property is subject to rent control and covered by the rent control ordinance. A review of the determination by the Bureau actually, we believe, supports the tenant's position. It goes ahead and lays out everything that shows that this property had been an apartment building, a dwelling. As we go forward, you will see, as set forth in the record, that and one more point of order. I did submit a late submission from Councilman Rivera last night, who resided at this property. He spoke last night at the council meeting, and he said, "I want to set the record straight once and for all, because it keeps coming back that this was he said brothel, because there's an article that says it might have been a house of prostitution, but that it's not a boarding house, that it had apartments where his whole family lived, and each apartment had its own kitchen and bathroom." And I have that, and I'd like to have it submitted to the board for their review. I think it's the direct evidence on this case that from 64, 65 to 1976, that was occupied by his family as an apartment building. The issue here today by the landlord is a claim that this property had not been a dwelling, that it had been a boarding house. The fact is, there is no evidence of a licensed boarding house. The landlord goes on to say that it doesn't have to be licensed, that if it's a boarding house, it's a boarding house. Well, such is not the case. If this board goes ahead and accepts an illegal use, as they will then validate that illegal use. There is no record showing that is a boarding house. Moreover, the tax assessor from Jersey City tax assessor, when questioned by Mr. O'Day about the property, flat out one sentence: it is an apartment building. So not only that, in the application to the historic preservation, federal application by the property owner, they list 20 tenements. Okay, a tenement is an apartment. It's not in the best of shape, and that absolutely is the case here, because in 1976, the power was shut off at the building. Now, how does we proceed tonight? Do I go, council goes, then I go again?
Depending on how much time is taken.
Okay, so then I'll proceed. In their papers, they provide an affidavit by a gentleman who was a realtor, and he states that the property was a boarding house. However, again, it was not a legal boarding house if it was. If anything, there were squatters. However, in the document, he says, as a real estate agent at that time, I knew the owner of the property, Egbert Cross. I toured the building several times with Mr. Cross after its operation as a rooming house had ceased, but prior to its sale and conversion. So he was not even there when he claims it was a rooming house. The fact is, the property was never licensed, and I believe at that time the only way it could be viewed as if there were squatters in the premises. Thank you. Okay. There's a Jersey Journal article, I think both parties cite. The Jersey Journal article says in 1976 that there was a fire, 12 families were dislocated, and 42 people had to be found homes, and all the power was shut off. The only thing happening in that building after that point would have been squatters. There is nothing to show a validity to a rooming house at that time. What we had before that were families, as stated by Councilman Rivera. He lived there. He lived in an apartment. He didn't live in a rooming house. He didn't share a bathroom down the hall. His family lived there, numerous family members throughout the building. And at this point, the fact is, in 1983, when the ordinance was changed to permit a property that was previously not a dwelling use, and it gives examples, the ordinance. It says a motel, a hotel, a guest house. There is no definition of guest house, okay?
Okay, the 3 minutes is up.
Okay, let me just sum up. So at this point, based upon the evidence that's before you, the valid evidence, I submit that this property was a dwelling, it was a residential house, and therefore, when it was converted and from 20 units to 15 units, as stated in the Zoning Board of Adjustment, again, the Zoning Board of Adjustment, the applicant, the owner, admits that it was an apartment building. So based on that evidence, it's clear that this was not a change from a non-dwelling to a dwelling. An illegal use is not a use. Okay? Thank you very much.
Thank you, Councilor.
Can you please explain how I can show the recording?
I think it's for the chair to determine if that should be submitted at the last minute.
Okay, again, if I can on that issue itself, the recording by Councilman Rivera, the statements were made by him last night. I was not able to get them beforehand. He went ahead and he stated it because the issue kept coming up, and he wanted to put it to bed. I have the recording. I can play it. It can be heard by everybody, and he is the best evidence as to what that property was.
I would also say that I would recommend allowing the landlord to respond to that
Right,
before
first.
you make
Of
the
Before,
course.
determination.
exactly.
Of course.
Let me speak to the landlord.
Sure.
Good evening. My name is Tom Cohn, appearing on behalf of Judy Shen, the owner who's seated to my left. My colleague is James Lehman, seated next to her. C-O-H-N. Thank you. Thank you also. And I do object to the submission of evidence, quote-unquote evidence, this afternoon. I was in a meeting this afternoon, got out of the meeting, hopped in my car, drove here, and first saw this when I was allowed to sit here and organize my notes for this meeting after 5 p.m. That's not a time to submit evidence. Another reason I object to it, and I want to place an objection on the record, is that Mr. Rivera has made 3 statements. Councilman Rivera has made 3 statements on 108 Sussex. And there would be no reason for the same person to make 3 statements about the same topic unless he was being goaded and asked to make those statements. So the first statement that he made was in July of 2023, never mentioned bathrooms in the hallways, never mentioned other uses. Then he made a statement in January of 2025. That's part of the record. And in the January 2025 statement that Mr. Rivera made, which was transcribed, he doesn't mention bathrooms. And then, for some reason, last night, someone approached him, obviously, and said, and I do agree with Mr. Murata, that Mr. Councilman Rivera said, I don't know why this can't go to bed. But when someone says, I don't know why this can't go to bed, they're obviously implying that it keeps coming up. And there's been no hearing. There's been no evidence. The statements were not made under oath. And I'd like to, therefore, say that this is not the time to be introducing new evidence. That's responding only to Mr. Murata's statement about submitting evidence this afternoon. And I object to that. I want my objection on the record. I thank you. I have not yet had the opportunity to speak. I was just asked to address the one point of introducing evidence received this afternoon. So I would like to reserve my time as to representation of the owner. Thank you.
If I may, just in response, it's correct. There were different statements. But as counsel stated, he was never under oath. He was never subject to a proceeding. He made comments about the property. So he was never questioned on when he spoke at the council meeting in January of this year. He was not asked how many, was it an apartment? He said, I lived there with my family. All my family lived there. True. There's no doubt that that can be taken out of context, that everybody, all the Rivera family lived in a boarding house. Again, it was not a licensed premises, and I'm not saying that they lived in a boarding house. After 1976, when they vacated and the place was shut down, then it was a vacant property, and if at most it was squatters. But going to Mr. Rivera's statement, Councilman Rivera's statement, the law is clear. Usually it's in the context of after acquired evidence, where something new comes up and you ask for a reconsideration because of that new information. Well, this came last night. This did not come tomorrow, so it's not in that vein, but the same premise applies. Fact is, Mr. Rivera spoke as to that issue. If this board requests further confirmation of that, they could always have testimony taken. And I would recommend that because I believe not only his statements that he put forward, which are true, I don't see there's any reason to discount Mr. Rivera on that, but I also understand he has pictures, family pictures, showing the property. Again, if that's presented at a later date, that would be after acquired evidence. So,
Right, so that was not submitted to,
no. But I do have a witness who saw the pictures. So And unfortunately, Mr. Rivera, Councilman Rivera could not be here tonight. He had another engagement. Otherwise, I believe he would have been here. So, thank you.
I think more importantly that if we're going to use his testimony, he should be here. If you're going to use him as an adjustment to what's going on, he should be here to
I
put that on the
appreciate
record for
that,
us.
but it was last night.
Yeah.
So, yeah.
So, all right.
The procedural rules say that evidence rulings shall be made to promote fundamental principles of fairness and justice and to aid in the ascertainment of truth. So that's what you need to decide.
Anybody? Any questions? Any questions, Mo?
I don't think it matters.
Okay.
Do the commissioners wish to call anyone? Okay.
Yeah.
No testimony from the hearing officer,
Yes.
right? Right,
yeah,
Loving
I was gonna.
administrator. It's up to you.
No, definitely. I want to hear from the court officer,
Yeah.
hearing officer. I'm sorry.
Well, again, we have a determination before you. There's no reference in that determination, unless I'm mistaken,
Okay.
that this establishment is a brothel, or I mean, really, all I saw was boarding house. So, do you want to get that
Right,
on
and
the
this-
record before, or would you? I mean, it's really entirely up to you if you motion to close.
Yeah, I was going to motion to close because it's. I mean, nope. The lamp.
Yeah, we
Yeah,
just
are we
have to
are we
get
just
that on
talking about just the admission of the
Well,
recording?
again,
correct?
yeah. Again, this is to the board. Do you wish to call anybody?
Speak to the landlord.
Okay.
Yeah.
Again, Tom Cohn here on behalf of the landlord. I'd like to the extent that any weight might be given to any of the three of Councilman Rivera's statements, I'd like to offer, and I'll try and do it quickly with references to exhibits, 10, I'm going to throw out a number to you, 10 unrefuted statements by different people over the course of years that this was not an apartment building. So we start with the Jersey Journal's May 1967 article that the building department charged that the premise was being operated as a rooming house without a license, Exhibit 14. The Jersey Journal in July of 1967, this is the brothel argument as if I created it. It's absurd. It was Reverend Martin Piasecki. He was the pastor of Our Lady of Czechoslovakia Roman Catholic Church. He said it was a house of prostitution. The police did everything possible, and nonetheless, in the first half of 1966, the police made 14 arrests at that location, 108 Sussex. Next, on Exhibit 12, page 315, the inspection notes require that the exact language is, what must be done is to install bathroom facilities. That's a municipal notice. It was sent by Inspector Brown and Inspector, I hope I'm pronouncing this correctly, Lobue, L-O-B-U-E. They said that it was necessary to install bathroom fixtures. Mr. Helinski's affidavit, which is Exhibit 6, page 91 tonight, says the property was vacant and uninhabitable, and he walked through it, and a gut renovation was done at the end of '83 and the beginning of '84. Mr. Zach's affidavit, which is page 248 tonight, said that his family lived in the adjacent property, right next door, for 3 generations, and he knew the property very well. And his statement was that it was a rooming house before its renovation. And that's page 248 of tonight's evidence. In the tenant's brief on page 13 of Exhibit 3, the statement is made that each unit, this is a quote, each unit has 2 principal rooms, comma, kitchen, comma, alcove, comma, and fireplace, close quote. No mention of a bathroom. From the Jersey Journal's February 1976 article, which is Exhibit 11, page 188, it states that the premises was vacant, there had been a fire, the premises were boarded up, and all utilities were shut off. And at the end of 1982, and we're now at Exhibit 3, page 24, that a renovator by the name of Property Rehabilitation and Development Corp.
3 minutes has passed.
I just have to refute. Thank you. I'll try and be quick. The renovator stated that the work was going to include the demolishing of the bathrooms and the modernizing of fixtures which are now inoperable. In the planning board, June 1982, Exhibit 6, page 80, the statement is that the application was to convert the building to apartments. Exhibit 7, page 108 from the Jersey Journal says, renovation plans are toilet and bathroom facilities for each apartment, replacing hallway toilets used by 2 families. That's Exhibit 6, page 80. Exhibit 12 at page 432 of the Jersey Journal in November of 1982 says that $425,000 had been awarded in permits in order to cause a renovation. I don't want to take too long, but the ordinance, which I'm referring to Ordinance Section 260, Section 1A, the purpose of the ordinance is to create good housing for moderate income people. And we're not in the 1890s anymore. But when that building was built in the 1890s, and Councilman Rivera said all the immigrants from Puerto Rico and his family, they were all coming there, in the 1890s, they weren't building buildings the way they do today. They did do them with common bathrooms. That's the way it was built. Now, we don't have that record. The city doesn't have that record, unfortunately, because of Superstorm Sandy. A lot of records were lost. But the purpose of the ordinance is to cause rehabilitation. Well, you got a vacant, boarded-up building, fire, boarded up, no utilities, 8 years, according to the planning board. And now someone comes along and renovates it and takes 20 units, makes them into 15. So I have to ask myself, and perhaps you'd ask yourself, why would any developer take a 20-unit building and cut it down to 15 units, thereby decreasing their possible income stream? And the only reason is because they had to put bathrooms in every apartment. They had to take 20 units worth of space, reduce it down to 15 units in order to create bathrooms in that space. There's no other reason a developer would try and shoot himself in the foot and cut out a possible source of income streams. So I do stress that the ordinance says any previous use. It doesn't say it had to be this or it had to be that. And I want to give an example of this in our brief. I think it's important. My name's Tom Cohn. I have a car in the parking lot outside. Let's hypothetically say I don't have a license, and let's hypothetically say that my car is not registered, okay? I'm going to leave this meeting tonight. I'm going to get back in my car, okay? Now, the car's not registered in my hypothetical. I'm not licensed in my hypothetical. That car is still a car. So this business about a rooming house not being licensed is absurd. It doesn't change the nature of the building. If the building was a rooming house with toilets in the hallway, that's what it was. Whether it had a license, nobody can find a license, nobody knows. We know that the fire department issued a violation. If you'll just give me a second to change. It was the building department and the fire department. In the May 1967 Jersey Journal said, this is Exhibit 14, the premises was being operated as a rooming house without a license. That's the citation. Well, this goes to prove that any prior use to be converted, which was the words used by the planning board, makes it applicable for rent exemption under 260A1. I also want to make one other point. I've listened to a lot of hearings that have been conducted by this board. And I've listened to tenants come here and say, I got a 20% increase. I got a 30% increase this year. Well, that to me is unfair, but I'd like to talk about this building. In apartment 7, the tenant has received a total, in 23 years, she has received an increase of 3.1%. I don't mean annually, I don't mean every 2 years, I mean over 23 years, a 3.1% increase in total. And the tenant in apartment number 2 has received a 0.05% increase. 0.05 increase in 13 years. There's nothing unfair about that. So we also know that 4 of the tenants who were miraculously listed as petitioners, even though they never participated before, 4 of the petitioners never filed a petition. I don't have anything to respond to. It's not appropriate to let them become petitioners for an appeal when I haven't seen what they're complaining about. They never submitted petitions. They never submitted complaints. So I just want to sum up, and I appreciate you giving me a couple extra minutes. The burden of proof in this matter is on the tenants. They're the appellants. They're the ones appealing the decision. They have to prove to you that their case is correct. And I think I've proven to you that the landlord's position is correct. And whatever Mr. Councilman Rivera might say, I just gave you about 10 examples that contradict what he says. Okay? I'm not calling him a liar. I think he's totally truthful. I believe what he said. I believe hitting a home run by playing stickball and getting the ball up to the 5th floor was what 9 and 10-year-old kids do. But I don't think 9 and 10-year-old kids remember everything. And, he said he wrote his initials in the wet cement at PS School 16. Well, I believe that he lived there, and I believe he wrote his initials, and I believe the kids had a great time. But that's not relevant for today. And those were what his 2 prior statements said, including the one that was submitted late, not today, late in January of 25. So
Thank you,
I ask that
Counselor.
you leave the 2 decisions alone. The 2019 decision, leave it alone. It says the building is exempt. And I ask you to think about something else. In 2019, a prior director said that this building was exempt from rent control. Did the landlord go out and send out 10, 20% rent increase notices? No. The landlord didn't send out any rent increase notices. You know why? It was the pandemic.
Sorry
Thank
to-
you,
to
Counselor. Thank you,
interject
thank
here,
you.
But I mean, again, we were going back and forth on the discussion of the evidence and whether or not we're going to admit it.
We're not.
Okay. Well, again, it's up to the commissioners, but I
I'm
just
not-
don't want to get off topic and then
Right, we're
jump
not gonna-
into
we're
the
gonna-
petition and then into the
Right, we're not
evidence.
going to listen to that.
Submission. So it's again.
No.
you have
Thank
the-
you for giving me a few minutes. I
We're not gonna
appreciate
listen
the
to it.
opportunity to speak with you.
If I may, I believe council has given quite a bit of time, and there's just a couple of statements I'd like to.
If you're going to say anything, Council, please speak into the microphone.
Yes.
Okay.
Okay, there are a couple of statements that were made that were just incorrect. Ms. Cruz filed a petition in 2019. She's right here. And another Gay Late Lawton, she filed a petition as well. She's not here tonight, okay?
Didn't receive a rent increase in 2019. Show me
The-
the rent increase. Show us.
Please address.
This is
Listen,
one
please.
at a time, folks.
Exactly. Only address the board, please.
The fact is that the property owner submitted year after year landlord registration statements admitting by the person they submitted an affidavit from, Kevin Halinski, the property is subject to rent control. That was their understanding. The determination by Ms. Hendon back in 2019 was 1 paragraph. This board goes through extensive time to make their decisions. She made a decision with 1 paragraph. I've reviewed the documentation. The property is exempt. That was it. This board goes through extensive review of the documents, states what the documents are, and then makes their decision. The fact is, her predecessor, Mr. O'Day, had looked into it, did not make a determination, as stated by counsel in their papers. That determination was not made by Mr. O'Day. Mr. O'Day did not make a determination at all. He asked the assessor, what is the property? And the response was, it's an apartment building. In the Zoning Board of Adjustment document, it states right here, the next matter for hearing is calendar number, and this is, Exhibit 11, page 163. Calendar number 2243, applicant Property Rehabilitation and Development Corporation, the predecessor to the owner here, to convert an existing vacant 20-family dwelling into 14 apartments and a penthouse. That's an admission. They're saying, the owner's saying it's a 20-apartment dwelling. I don't know how we can get past that. I understand the board does not want to hear the recording tonight. from Councilman Rivera. The board does accept hearsay testimony, I believe, and my client watched the council meeting. May I call her to state what's stated by Councilman Rivera?
I object. That's the most hearsay of hearsay.
Again, if anyone's going to speak, please wait till you're called and speak into the microphone for the recording and for the stenographer. Thank you.
So so I would request to have her approach, and she could put on the record what Councilman Rivera stated.
No.
Okay.
No, we don't need that. We don't need that.
Okay. So again, I believe the documents, a review of the documents will show that other than newspapers that precede Councilman Rivera's occupancy of those premises, that from his time in mid-60s to 1976, the property was apartments.
Okay, thank you, Counselor.
Thank you.
Let me hear from the landlord counsel one more time.
And just to clarify for the record, the board is not willing to admit this into evidence, Councilman Rivera's statement at last night's council meeting.
Yes.
Okay. All right. Just wanted to get the record clear.
Of course, he has two other statements that have already been placed on the record.
Go ahead.
I object to, for all the reasons I stated before. It's beyond the pale of what's credible evidence for somebody to say, well, I heard somebody say something. I don't know what questions he was asked, but I heard somebody say something. That's not evidence. I've given you my 10 examples. And in the June 1982 Planning Board application that was just referred to by Mr. Murata, it doesn't say apartments. He's absolutely wrong when he uses the word apartments. Mr. Chairman states, the next matter for hearing is calendar number 2243. The applicant is Property Rehabilitation Development Corporation to convert an existing vacant 20-family dwelling into 14 apartments and a penthouse. It didn't say what he just said. He said that there were 20 apartments, and that's what's in the record. But I'm reading to you from the record, and it was also submitted by Mr. Murata. It's to convert an existing vacant 20-family dwelling into 14 apartments and a penthouse. Convert. So I rest on that. I ask that you please, once again, consider what has been submitted by the landlord. Consider my oral argument. Consider what the purpose of the ordinance is in terms of creating good housing. The 1890s, the 1960s, and the 1970s are not Jersey City of 2025. Okay, this city it's unbelievable. It's incredible what's happened in this city. And I see these towers that are 50 stories tall, but this building was brick and mortar. Okay, it was built in the 1890s. Okay, I don't know how we can possibly all put our minds back in the time frame of the 1890s and imagine what it was like to be an immigrant to come over here, but you didn't move into one of those shining towers on the river. That's not the kind of housing that was here. So I ask you once again to reaffirm the decisions which have been reached, and again, I thank you for your time.
All right, thank you.
Well, actually, I did have one question. Actually, it was going to be a question that's going to be posed over to the rent leveling agency. And I know, and not trying to be too much of a stickler, but 260-6D does require that there is a written statement from the Division of Tenant Landlord Relations that if a building is vacant, that they actually supply something in writing to that nature. Do you know if anything was ever submitted documenting that it's
I'm sorry, you're referring to subsection is 260-
260-6D?
paragraph D. Okay.
The last sentence reads, officers designated by the Director of the Division of Tenant-Landlord Relations shall be responsible for certifying in writing that a dwelling is vacant as of July 1st, 1998. I'm just curious, that's all.
As of the record, no, I don't know that that the office has submitted anything, if you will, in writing.
Okay, no, it's not a problem. Wasn't trying to catch anybody off guard. I was just
Absolutely.
curious as to whether or not there was anything in writing.
Any other questions? Anybody else have any questions? Okay, motion to close the public portion of this meeting.
Okay, I have a motion by the chairman, Mr. Dana Hale,
Second.
second by Commissioner Isikoff. All in favor?
Aye.
Okay. So now
Okay, fellas.
session is closed.
Anybody have a position?
Anybody got a position?
I think it's exempt. Oh, I thought this is closed.
Sorry, commissioners, any discussion we want on the record, so,
Okay,
okay. Please speak into the microphones.
all right.
Thank you.
Just give us a second. Got that one. Mark, you wanna? Anybody wanna say something? You can say something. Anybody
We
wanna
can't
say-
hear what you're saying.
No, I'm just confirming to commissioners. Anybody want to pose a motion first?
Can we ask any further questions?
I would encourage that.
Yeah.
Okay. Now you have 4 tenants are petitioning this rent increase. So if this building is found exempt, what happens? Do the tenants have any further recourse?
If the building is found exempt,
Exempt from rent control?
right, outside of this office, there's no recourse outside of whatever you decide, and that gets appealed and goes
Okay.
to Superior Court. Yeah, if it's exempt, then they cannot file a petition with our office because we only have jurisdiction over rent control properties.
All right, thank you.
May I respond to that question as a lawyer who does a lot of landlord tenant?
It's closed. Oh, all right, Counselor, be brief, please. Really, really, really brief.
I promise you I will be brief. While exemption from rent control does provide certain limitations and circumstances regarding rent increases. There is a state law that is available to every tenant in every landlord-tenant case. And it says that a landlord shall not be permitted to make an unconscionable rent increase. That's the exact language of the statute, an unconscionable rent increase. And what that means is 4 and 5% increases are okay, 7 and 8% you're in the gray area, 10 and 11% you're in trouble. So there is recourse for a tenant, to respond to your question, sir, that you can go to court, say the rent increase was unconscionable, too high. It's available to all tenants.
If I may, I disagree with counsel respectfully. There is no statute that provides for that. The issue on unconscionable rent increases is by case law, and it's by the judge. Counsel has stated that 7 or 8% is in a fuzzy area, not his exact word. However, the increases have been 7 to 9% over the last 3 years to my clients. Jersey City is suffering from the biggest rent increases of all time, and nobody has a place to live now.
Okay, thank you. Thank you, Counsel.
Thank you.
All right. Randy?
If I could, I would just like to speak to the tenant's landlord, attorney again. Is it Morato? No, I'm sorry, no, Lehman, I apologize, the landlord. It's Lehman. The issue about the, there has been, I think,
Are
some
you speaking
argument.
into your mic, Commissioner?
Yeah, there's been some argument, I believe, in the documentation on your behalf that the ordinance, this 260, the ordinance and the nature of the ordinance, that it does not require a rooming house to be licensed in order to qualify for the exemption. And I was just trying to get you to clarify a little bit more as to why.
It's an absence of records more than anything else. The premises was built in the 1890s. I don't know anybody who can think about what a walk-up building was like in the 1890s. It wasn't middle-class housing. It was for immigrants. That's what Mr. Rivera said too. And you didn't get your own bathrooms in those days. And even in the tenant's petition, which I cited to, they described the building as each unit consisting of, the tenant's brief, page 13 of Exhibit 3, quote, each unit has 2 principal rooms, a kitchen, an alcove, and a fireplace, close quote. So I'm not trying to, the language of the ordinance, which I'd like to address again briefly, says any prior use. That's the exact language that's in Section 261A, from any previous use. So it doesn't matter whether it was licensed or not licensed, or it was a rooming house, a boarding house, a transient, there were squatters. It wasn't an apartment building. And the definition of dwelling is set forth within the municipal ordinance. And this property does not meet the definition of dwelling, because while you can have an individual, you can have 2 best friends, you can have a couple, you can have a family, but what you have to have is your own bathroom. That's what makes it a dwelling. And that's not only case law, that's not only the ordinance that we're dealing with tonight, that is also case law from the Appellate Division of the New Jersey Supreme Court, and it is also the definition that is used by the United States Supreme Court. And James Lehman, can you help me with the citations for that, please? I'll give you Supreme Court law and New Jersey Appellate Division law that defines dwellings. It's in our brief, but I can't find it fast enough. Just give it. Okay. The case was Schneider, and it's set forth in our papers, although I don't have a citation for you, but it's in a couple briefs ago. The Schneider case says, a building was operating as an unlicensed rooming house, even though family members lived there, and it was an unlicensed rooming house because they shared the building with non-family residents who had discrete living spaces but shared access to bathrooms. The next case was Country Lane. This is United States Supreme Court. A rooming house is based upon shared bathrooms. And that's the exact language out of a Supreme Court case. So whether you think it was a rooming house or a boarding house or something else or a transients or squatters, whatever it was not an apartment building when it was built. There's no question about that. And that's my 10 examples with 8 newspaper articles and affidavits and everything else. All those people can't be wrong and one man is right. It's not possible that 10 other people are wrong. 10, and all
Okay,
the
thank
newspaper
you,
articles.
thank you, thank you, thank you,
Wilson.
thank you.
Yes, I'll be brief in my response. First of all, counsel bases his statements on facts that there is no way he could know. He starts out with the building being built in 1890s. It was a walk-up. It didn't have bathrooms. There's no way he can know that. It's just not possible. Okay? So it's being inflammatory, I believe, in some respect, to go beyond what the actuality is. The Zoning Board of Adjustment application specifically states dwelling. The definition of dwelling in the ordinance specifically states, any building or other structures containing housing spaces rented or offered for rent to one or more tenants consisting of a household or family as defined in this chapter. There's no discussion about bathrooms, but it is a dwelling. The fact is that this property, even based upon the Jersey Journal article where 12 families were displaced. I understand the board does not want to hear the recording of Councilman Rivera. Again, I would request that the board carry the matter so that Councilman Rivera can either provide an affidavit or be present. And also, council's witness, Mr. Helsinski, can also appear. The fact is, there is nothing stated other than newspaper articles in the 60s that this was a rooming house. Their witness that provided the affidavit does not have specific knowledge. If you read the affidavit, he says he was in the building after he says it was a rooming house. He wasn't in there when it was allegedly a rooming house. So the facts are clear. This was an apartment. The documents presented, 20-unit tenement. Definition of tenement, apartment. That is the applicant's own words.
Okay.
Thank you very much.
Thank you.
Isn't it, just to clarify, isn't it typically, I think the landlord lawyer, you said that it was a 20-unit building or 20-family building?
Yes.
Right.
When the building was originally constructed, there were 5 floors, walk up of 5 floors, ground level is the first floor,
Right.
second floor, third floor, fourth floor, fifth floor. As you get to the landing on each floor, you can turn left, you can turn right. Whichever way you turn, there's 2 units, dwelling units, that have bedrooms and kitchen facilities down that hallway.
Right.
So if you can imagine this, when you
No, but
turn down the hallway,
Yeah.
unit, straight ahead is the bathroom.
Right,
It's
but
not
my
inside the
question,
unit.
my question is more like, isn't it typical to use unit and family are interchangeable, right? In terms of you have a 20-unit building, you could also have a 20-family building. It means exactly the same thing.
Well, they might, yes, they might. And in the ordinance section that Mr. Murad has just said, it says family is defined later in the ordinance, except it's not. But I would say this, that you could have a dwelling unit with a family in it, there's no question. It's a family dwelling unit. I totally agree. It's a question of what facilities it has. And
Is it typical to list that a bathroom is part of that in every single unit, or isn't that
that is a
assumed?
requirement for a dwelling.
Okay.
And I ask that you please look at our case law
Right.
as to what constitutes a dwelling. And it does, but it doesn't matter how many people are living there. They can be, I would say in response to you, sir, that anybody who's living there constitutes a family unit. Whether it's one person or a mother and dad and kids, whatever it might be, they're a family unit. But that doesn't make it a dwelling if they've got to go out in the hallway to use the toilet.
Right.
So,
Right,
thank you.
understood. Thank you.
Make a decision, man. Let's go. What's the motion? What's the motion? What's the motion?
I don't want to stop you from asking questions. I just want to reiterate that
I
they
just-
should be on the record.
Right. No, no problem. I got it. Okay.
I'd just like to, if the landlord's attorney could approach the podium once again.
Yes, sir.
I guess where my level of uncomfortableness is this issue about a dwelling. So
I'm
if
sorry?
you could, dwelling. If you could kind of concisely and kind of like, speak to me like a fifth grader, and
Okay. so
your
we have a
argument that this does qualify as a dwelling.
Okay, so we have several different definitions of dwelling, and the first one comes from the ordinance itself. And that's section 260A, I'm sorry, 260, 260-1. The section defines dwelling, quote, dwelling, as follows. Any building or other structures containing housing spaces rented or offered for rent to one or more tenants consisting of a household or family as defined in this chapter. And then it talks about exemptions. There is no definition of family that comes up later. So I've accepted, and perhaps some of you have accepted, that a family can be pretty much any group of people that live together. I mean, they don't have to be married, they don't have to be parents and kids. I mean, it could be two best friends, it could be roommates from college, I mean, it could be anything. That's family, okay? But that's not the definition for dwelling, because a vacant building, for example, is a non-permanent dwelling. And the Supreme Court case that I was trying to find before, Texas versus Florida, United States Supreme Court case, says that a property is considered vacant if it has been unoccupied for approximately 1 year and necessary utilities were disconnected. This building was vacant for 6 to 8 years. That's what everybody says. So in considering, the critical inquiry is whether the unit was available and suitable for rent in and of its own. A building that has sat vacant, abandoned, and uninhabitable is no longer a permanent dwelling. I'd like to read it again to try and respond to your question. A building that has sat vacant, abandoned, and uninhabitable is no longer a permanent dwelling. This is from the Texas versus Florida United States Supreme Court case. Did I respond to your question,
Yes,
sir?
you have. I appreciate it. Thank you.
Sure.
If I may.
Okay.
Just on the definition of dwelling, I believe that we have to look at the actual definition and stay within the definition of dwelling, which states, any building or other structures containing housing spaces rented or offered for rent to one or more tenants consisting of a household or family as defined in this chapter. I understand household and family are not defined in this chapter, but a dwelling is where they live. We have articles that say 12 families were discharged from this property. So it falls within the definition. The reference to the Supreme Court case, and I addressed it in my brief. However, at Exhibit 13, page 437, the Texas versus Florida case is a case involving 4 states where the owner of a lot of property was trying to bounce around to have the best tax impact that he could receive. It was not about the definition, as stated by counsel. The case has nothing to do with the status of a property as a permanent dwelling. The court's focus was to determine whether Mr. Green, the decedent in the case, abandoned the various properties as his principal domicile to determine which state had a better tax revenue. The fact is, the cases stated by counsel, the other cases, deal with criminal matters and whether something is abandoned for the purpose of somebody going in and damaging the property, whether they be held to a higher standard. So the fact is, those cases do not support the argument. However, the definition does. Thank you.
I got one question. The to the owner, the property was vacant before 1983, right?
Yes, in 1976, there was a large fire. 12 families were displaced. The building was in such poor condition that it was boarded up, deemed vacant. All utilities were cut off, no water, sewer, electric. It started in 1976, because we know that's when the fire was.
So from 76 to 82,
Two,
it was vacant.
correct. Boarded up, no utilities, no water, no electric, no gas,
No tenants, no nothing, right?
tenants.
What happened in 1982 then?
In 1982, somebody got the wise idea that it would be great to take a building that's been sitting vacant and turn it into decent housing. And Robert Fulton and his company, that property development company that I referred to earlier, got mortgages from a bank called Northeastern Bank of over $1 million, and he got a grant from the city for $425,000, another newspaper article I've cited, and he went about and rehabbed the building. And he did it. I never met the man, and I don't know him, but, you know, the opportunity to take an abandoned and boarded up and vacant building and rehab it is attractive to a lot of developers or people who know how to do that. And Mr. Fulton and his team got that done in 1983 and 4.
Okay, thank you.
Thank you.
All right.
Again, just briefly, we got to watch a slippery slope here. If a vacancy is determined to be a non-permanent dwelling use, then every temporarily boarded up building will become exempt from rent control, and we will have the end of rent control in Jersey City. Vacancy is not a use. The ordinance says a prior use. And here, there was no boarding house. There never was. To permit a boarding house that is in violation of law and recognize it as such is wrong. And the facts that have been presented that are documented, including the historic preservation application, the zoning board of adjustment application, which states dwelling, that is the documentation that has been presented by the prior owner and that is relevant to tonight's proceeding. Thank you.
Thank you. Okay, we have a motion. As I'm reading in, the landlord has provided sufficient proof of compliance with 260-1A and has previously been determined by the Housing Preservation, and there was no new evidence has been provided to determine otherwise. Therefore, that the property was not subject to rent control. I second that motion.
I'm sorry, what is the motion exactly?
Motion to accept the decision from the rent, from the tenant landlords
To affirm
to affirm
the hearing
the
officer's
decision, hearing
recommend-
officer's decision based on the information. Oh, I'm sorry. All right, I'll put that in the record. Okay. Okay. All right. Determined by the two housing preservation directors, Dina Hendon and Charles O'Day, that there was no new evidence provided to determine otherwise. The reason why I'm putting that is because of from 76 to 82, the building was vacant. There was nothing, no movement. Everything was shut off. There was nothing there. The previous owner, I guess, came in, bought the building, established housing for tenants to move in. At that point, in 83, it was put on as on the record as a building being occupied by tenants, but there was no ordinance to put them in the rent leveling situation. So because of that is why I'm suggesting and giving my opinion on.
Okay, so you're saying that then it would be exempt under 260
1A.
1. Yeah. Okay.
Yes.
Okay, just to clarify, you're making a motion to accept the hearing officer's determination that was submitted, that was published December 24th, 2024, right?
Right.
Okay. Do I have a second?
Second.
Second.
Okay, we'll have a roll call. Alexander Hamilton,
No.
Chairman Hill,
Yes.
Commissioner Eacock,
Aye.
Commissioner Isikoff,
Aye.
okay, Commissioner Brown,
No.
okay, and Vice Chair Johnson.
I abstain.
I'm sorry?
I abstain.
Okay, abstain. Okay, so that is 3-4, 2 against, and 1 abstaining. The motion passes. I'm sorry, that was three yeses, 2 noes, and abstention. It passes. Okay, motion passes.
Thank you.
Thank you, everybody. Have a
All right,
nice
thank
night.
you.
Okay.
Sorry, Dan. I should have made that motion.
That's okay. It's all right.
Folks, we're going to take a break for 1 minute and convene.
Good evening. Thank you very much.
Who's that girl?
It's a friend of mine.
Oh, that's a friend of yours? Oh, good.
Hi, this is Tony Aquara. Somebody just.
Here we go again. You again.
Just me.
Oh my God.
I'm usually sitting in the front.
Listen, right?
All right, Chairman, thank you.
I think we're ready to go to the next.
Okay. Next case we're calling is
No, yes.
129 Magnolia.
Hi. Good evening.
Good evening.
Adrienne Lepore from Goldstein Kellen for Magnolia Apartments, 129.
Go ahead.
You ready? So my client submitted an appeal of a vacancy capital improvement application. They submitted a vacancy capital improvement application in April of 2024, and they were provided with a calculation based upon their application in November of 2024. They submitted an appeal of that application, and it's that appeal that we're here for today. There was no determination by the rent leveling officer that the submission was incomplete or not in compliance with the ordinance. Instead, the officer decided, I'm going to take my glass off, decided that instead of using the amount actually spent by the landlord in improvements, which was $72,764.64, they reduced the cost to an arbitrary amount, to saying that it exceeds the estimates provided by the National Home Improvement Estimator. The National Home Improvement Estimator does not appear anywhere in the ordinance, nor does the ordinance provide the board the ability to reduce the amount of if the landlord can show that they actually spent that amount on improvements, and they reduce now the allowable increase based upon an approved amount of $45,974.36. So the ordinance says specifically that in the event of a vacant housing space, they can make application. They may raise the rental above the cost of living increase without prior application being made to the Bureau of Rent Leveling. And that's important because it says only if he or she has made capital improvements to the housing space. Such capital improvements will entitle the landlord to increase the base rent of the unit by the following amount. And the amount is the capital improvements up to $5,000 in value based upon, you all know, based upon a percentage, and over $5,000 based upon a percentage. That language does not say for some other amount to be determined reasonable by the board. It says for the amount essentially actually spent by the landlord. And that's the amount that the landlord raises a tenant's rent by prior to application, because they're relying upon the language in the ordinance. If this board is going to apply a standard that's not in the ordinance and not strictly comply with the ordinance, there has to be a change in the ordinance, because due process requires that to landlords. They rely upon what the ordinance says when they set that rent. And for them to get a calculation that's lower than, based upon an amount less than what they spent, they're essentially, this board is taking something from them that they're not permitted to do. I don't know if any of you are familiar with, and there's a lot of cases that talk about strict compliance with ordinance by boards, but I'm referring to one specifically because it was before the Jersey City Rent Leveling Board, and it was called Bishop Property Management and Magnolia Management, unrelated to my client, versus the City of Jersey City Rent Leveling Board. And in that case, to sort of sum it up, the rent leveling office had been employing a standard of calculations for hardship stays that was not in compliance with the ordinance, and they were doing it for 40 years. They even had it on their rent leveling application for a hardship stay, and they said to the landlord, you can use this calculation. A landlord submitted a calculation, and the board said, we're not using that calculation. We're using the amount in the ordinance. We're using the, I'll tell you exactly what this says. They were abiding by the express language of the code, of the ordinance, not what the office had previously been doing. And the case was appealed. The board said we can abide by the code, even though that's the way we should abide by the code, even though the office was doing it a different way. And on appeal, the judge determined that the board did not act arbitrarily and capriciously in abiding by the express language of the code. To the contrary, the judge found that the board, accepting plaintiff's definition of equity, which was something other than the code said, would have been an arbitrary deviation from the code's express language. And I submit to the board that using this standard, by that other agent, I don't remember what it was called, using the standard set by the National Home Improvement Estimator is deviating from the express language of the code. It's taking away from a landlord's right to rely upon the express language of the code. And because the code gives the landlord the ability to raise the rent before actually being approved, even more so the officer and the board should strictly comply with the ordinance, because no one would expect that it would be reduced by some. It would be like saying we're using the CPI based upon the average in the New Jersey, New York metropolitan area, and then the officer deciding we're actually going to use a CPI based upon the average in the metropolitan area somewhere else. That's not what the ordinance says. The landlord has to be able to rely upon what the ordinance actually says. So reducing it by $30,000 was arbitrary. It was not in compliance with the ordinance, and the calculation should be based upon the amounts actually spent by the landlord. I did submit some supplemental documents in the event there was no actual determination. I don't think that I saw by the officer that any of the amounts or invoices submitted by my client were incorrect, or that they didn't think that they were unreliable. It was just reduced based upon that other But I did submit additional ones in the event the board found that they needed to see more invoices or paid receipts so that the $72,000 was fully accounted for.
Okay, thank you. Can I hear from the hearing officer?
Yes, I do. A couple of things. I was hired 7 years ago specifically to evaluate construction and the construction that's done for capital improvements and for vacancy capital improvements. I'm not saying that the applicant or the owner did not spend that $72,000. It's whether or not we feel it's exorbitant or overly priced. I'm definitely not questioning that they spent the money. At the last vacancy capital improvements that the applicant put in April of last year, the board determined that we were using a price of approximately $128.42 per square foot to evaluate and to base the apartment renovations on that number. I basically took the same number for their new application for unit number 7. When we're going through, there's units that are going, that people say they spend $180,000, and we go through and we reduce them. Basically, it's my job to see whether I think it's fair and reasonable. That's where, and I use that when we use the calculator.
Inspector, we're talking about the Magnolia Apartments 129, right? The November 13th report?
Yeah.
Okay. So that lowered what the landlord had claimed.
Yes.
And then on June 3rd, so that was November 13th, 2024. And then on June 3rd of this year, the landlord supplied additional proofs of the cost of the improvements. Did you review those?
This is for apartment number 7, correct? The hearing tonight?
Yes, I believe so.
Right.
207.
207, I'm sorry.
Yes, I would like. Can she address that? Sorry.
Those
Yeah.
proofs that were submitted just supplemented what you already reviewed. So, like I said, I don't think there was any determination that and I think you just stated
Right.
that he's not finding that the $72,000, he's not finding that the $72,000 wasn't spent or the landlord couldn't back it up. Just that he's using it, some other reasonableness standard, which I'm arguing you can't do because that's not what the ordinance says, and landlords aren't on notice of that, so they are denied due process if you're going to change the standard. So I did submit additional proofs in the event for some reason you needed more backup, but it wasn't really relevant to my argument with regard to the strict compliance with the ordinance.
Okay, all right.
Question,
Yeah.
just quick question, Tom. So I think that's really quite relevant too. This additional proof that was submitted June 3rd, and whether or not you've had an opportunity to actually go through that.
No, I don't believe I did, but again, I'm not questioning whether they spent the money or not. I don't think that's the issue. It's just whether it's reasonable for the size of unit that they were renovating. They put $72,000 into renovations for a 358 square foot unit. Again, that's coming out to like $203 a square foot, which is comparable to new construction price of building a building from the ground up, including the foundation. That goes anywhere from $200 to $220 a square foot. And most construction is based on square footage. I know not all of it is, but most construction is based on square footage. So if one unit, in their previous applications, one unit was going for renovations were for $133,000 for a 1,058 square foot unit. A much smaller unit was, I'm sorry. A 350 square foot unit went for $74,000. So basically, over 2/3 of the price of the unit that was 3 times bigger. So that's where I came up with the dollar per square foot for the previous cases, and the dollar per square foot that we wound up at is 128.42. I applied that to the new unit for the new application, and that's where I came up with the number.
Okay. All right.
So I don't think they're apples and apples. This building is 100 years old. The unit 207 hadn't been renovated in more than 30 years, so it needed upgraded electrical. I don't know what the other one needed necessarily, but this was a gut renovation of the unit. The other one may not have needed to go down to the subfloors and replace floors. It may not have needed new plumbing and new electrical and all new. I don't know what that was, but again, with a building this old and a unit that hasn't been renovated in more than 30 years, it certainly, my client spent $72,000 because that's what it cost to renovate it. If you see the before and after pictures, it's a beautiful new apartment. It's not like they did a shoddy job. They did it like it was a gut renovation, new construction apartment.
Okay, thank you. Thank you, Tom.
Just one question, and it mainly goes to the code. Do you have the authority to make a reasonable test? We appreciate a reasonable test.
I can't cite exactly where it is in the ordinance, but I believe that the office does have the right to determine if the costs are reasonable. And that's basically what we're saying. I mean, again, I'm sure we're not contesting whether they spent the $72,000. I'm sure you could also find a contractor who would charge you $100,000, and you could also find a contractor that would charge you $60,000. So where is the reasonable amount in what they're spending is basically what I was technically hired to do. That was
Gotcha.
specifically why I was hired.
Gotcha.
All right, thank you.
All right.
I just have one question about that too. The process for figuring out what's reasonable, you said most of it was based on square footage?
For
solely?
most construction is.
So it's based solely on that?
Yeah. Well, it also depends, we've discounted amounts based on when they really strictly line itemize their entire construction budget, where, again, I'm just giving an instance, they say painting an apartment was $8,000.
Right.
The price per square foot is normally $5 to $7. We figure out the square footage of the apartment and base it on that. It depends on how much of a breakdown the applicant gives us. Some of them give a very, very detailed.
Okay. I just didn't know if quality of materials was taken into account.
It does.
Okay.
There is provisions for the Bureau to look at reasonableness and hardship applications and the like, but to the counselor's point, I don't see in 260-3, paragraph C, which is for vacant space capital improvements, a reasonableness review. I do think that it says for capital improvements up to $5,000 in value, and maybe that's where we're getting it, is just because I pay $100 for something doesn't mean it's worth $100. Is that an interpretation that people want to work with? I'm not sure.
I have a question that's not related to what we just spoke of, but in terms of 260, the definition of capital improvement specifically excludes repairs and maintenance. And
Looking at major capital improvement.
I'm looking at capital improvement, period, the definition in 260. And I see repair of subfloor and bathroom and kitchen. So
260, you're looking at, 260, which provision?
the definition of capital improvement and definitions.
60-1.
Yeah.
260-1, the definition of capital improvement is referencing a capital improvement when there's a major capital improvement. That's a permanent improvement that adds value or extends a useful life. I would contend that a vacant space isn't talking, they're talking about all renovations. I've never seen the office or the board limit replacement of anything for a vacant space capital improvement. If it's a gut renovation, it's the amount actually spent.
Again, definition of capital improvement clearly states a permanent improvement that adds value or substantially extends the useful life of the landlord's property and can be claimed by the landlord for depreciation of his or her federal tax returns. Specifically excluded are ordinary repairs, maintenance, and conversion of hot water units.
So there weren't any ordinary repairs, maintenance, or conversion to heat or hot water. This was a gut renovation of and replacement of the entire apartment. An ordinary repair or replacement is very different.
Repair is repair. Capital improvement is capital improvement.
Correct.
You have submitted repair subfloor and bathroom and kitchen. I don't see any breakout for that cost versus new cabinets, for example. It's all lump sum.
Can you point me to which,
Exhibit, 1P3. It's also on
hold on.
P9. It's also on P5. I think it's just one plan that's installment pays. So it's the same verbiage for all.
I see demolish as per plan, remove old wall and old floor. They demolished it all. So if they're using the word, I don't see where you're saying repair, but I.
Repair's about
Looking at this
halfway
one that goes
down.
all the way down this long skinny thing. I don't know what that.
Yeah, we're about halfway down. It says repair subfloor and bathroom. Anyway, the point is, when you give us, lump sum, like this is 300,000, this is 30,000, this is 10,000.
Well, that's why I submitted the supplemental. If you look at what I submitted on June 3rd, the supplemental application, it breaks everything down.
Mm-hmm.
Let me see if I can go back. So if you look at the first, number one, demo labor and material, demo cleaning, the invoice and receipt talk about demo walls to studs and ceilings to beams, provide and carry out all debris, and also bathroom and kitchen cabinets. Price will include labor and dump fees, demo walls and ceilings, no subflooring. And then attached to that is the cost, the paid receipt for it. So when my client submitted the initial application and typed all of that in, it's more specifically from the contractor, detailed in the supplementals.
Yeah.
I do have the contractor here, if you want to ask if he has repaired the subfloor or if he just demoed it down to the subfloor.
No.
Nope. You hear from the hearing officer again?
That's okay. In part of the ordinance, it states the board, in computing the amount spent for capital improvements, which we have always taken to mean all capital improvements, both vacancy and capital improvements, may consider reasonable value of construction services performed by the owner in the actual capital improvement work where allowed. This shall include professional consultation and other similar services of the owner and is limited to actual labor and materials invested by the owner. That's when I was trained that this was part of capital improvement, and the board is to evaluate it.
Tom, well, a question I would have also would be the supplemental documentation that was submitted by the landlord.
Right.
Is it going to significantly change what your computations were?
No.
Right.
No change in the numbers.
Right. Gotcha. All right. Just want to make sure that was clear for the record.
Reports the
that's all.
numbers more specifically, but the number's the 72,000 in the end anyway.
Any more questions?
No.
All right. Motion to close the public portion of this meeting.
Second.
Get a second? All in favor?
Aye.
All right. All right, somebody want to read the recommendation?
Okay, we've had a motion to close the public hearing. It's been second.
It's been second.
All right.
Okay. You wanna read it? I don't know.
Anybody? Well, I'd like to make a motion that we accept the request made by the landlord, by the property owner, given 260-5. It seems like it does meet the the guidelines, and given what we've heard from the hearing officer, I think that they've documented their case, and I think that we should just proceed accordingly.
Second.
Guy speaking to the mic, he couldn't hear.
Can you please repeat that?
Second.
I didn't hear the motion.
Okay, I'd like to make a motion that we accept the numbers that were, submitted by the hearing officer and accept the case that was presented by the landlord, at least by the landlord's attorney, and that we proceed accordingly. They've met the stipulations attached to 260-5, and I'm prepared to vote that we accept the documentation as submitted.
So are we making a motion? Are we affirming the?
Yeah, I guess
Okay.
it's the matter of the language which I might be confused with.
Okay,
But yes,
okay.
that I would be affirming
The re-
the position taken by the
Hearing officer.
hearing officer as well as the arguments that were presented by the landlord.
I guess I'm confused because the landlord is saying a higher increase than the hearing officer is saying.
Right, so,
Well, I got the impression, and point of clarification for me, that the numbers that were presented by the hearing officer are not going to change. Okay, I see what you're saying.
They're lower.
Then I need to clarify my motion.
Okay.
okay. No, but he,
The point of clarification, and I need to correct it. I make a motion that we accept the calculations presented by the hearing officer, and that they appear to be reasonable, and they have met the guidelines established in the capital improvement and service charge in statute 260-5.
Okay. So we have a motion to affirm the hearing officer's determination. Do I have a second?
Second.
Okay, we're going to put this for a vote. And so in case, in case VCI 2024-0092, this is 129 Magnolia Avenue, Unit 207, the vote is to affirm the hearing officer's determination. Alexander Hamilton.
Yes.
Dana Hill.
yes.
James Eacock.
Yes.
Mark Isikoff.
Yes. Yes.
Michael G. Brown.
Yes.
Sullivan C. Johnson.
Yes.
Okay, we have 6 yeses, no, 0 no's. The motion passes 6-0.
Next case, capital improvement, 289 Barrow Street. (289 Barrow Street). No one here for it?
Okay.
You read into the record? Hear from the hearing officer.
Yes. I actually spoke with both the landlord, the property owner, and the representative of the tenants, who they both agreed with my finding of capital improvement increase of $24,933.38. I would only ask that we clarify it with one provision. When I made this recommendation, I was under the impression that every single apartment in the building had the same number of rooms. They do not. So I would ask that you affirm the capital improvement in the amount of $24,933.38. However, it would be allotted based on room numbers per apartment, not that each individual apartment would get a $29.68 per month raise, if the board is able to do that.
Yeah, I think the board can do that.
Yeah.
You're just modifying your decision based on, or your recommendation based on what you're telling them, so.
Do we need to close it and then do that, or?
Just one question. I mean, it does look like it's based on room count.
I'm sorry.
I have page 55, that was the calculation. So, I understand what you're saying, it's fine, but it already seems to be apportioned by room count.
Yes, but I believe that that count is not correct.
Oh, I see.
And that was indicated by both the landlord and the
So
owner.
in total, is more than 20 rooms.
Yes. Or the,
okay.
yes.
Because, yeah, this comes to 20. Or maybe it's just a different reallocation of rooms.
Right.
Among the 6
But
apartments.
among the apartments, correct.
Oh, okay. But overall,
Well, based on the original, I'm sorry, on the determination, it was per unit of $29.68. When it's being based on room number, some apartments might be slightly less, and some apartments might be slightly higher, and the representative of the tenant organization is aware of that.
Right.
So that's the average,
Yes,
basically.
yeah.
Do we need to close this, or we can
Yeah,
just?
you can make a motion to open and close public comment.
Okay. Motion to close public comment on.
second.
Okay, motion has been given and second to close public comments.
Somebody make.
All in favor?
Aye.
Aye.
Opposed? Motion carries.
Motion to adopt the hearing officer's recommendation for capital improvement for 289 Barrow Street, based on that he spoke to the landlord and the owner. They came to an agreement on the property itself, based on the apartments and the amount of rooms that are in. So we're carrying a motion to accept the hearing officer's decision.
So we're pretty much making a motion we're modifying we're modifying the original based on the hearing officer's recommendation. So we're
Yes.
modifying based on the hearing officer's recommendation. I'm sorry about that.
Yes, modifying.
Okay, so we have a motion to modify the hearing officer's determination based on his recommendation that's on the record. Do I have a second?
Yes, second.
All right, so we're going to vote. We're voting now. This is case number CI 2023-0019, and we're making a motion to modify the hearing officer's determination based upon the recommendation that was given. Alexander Hamilton,
Yes.
Danon Hill,
Yes.
James Eacock,
Yes.
Mark Isikoff,
Yes.
Michael T. Brown,
Yes.
Sullivan C. Johnson.
Yes.
Motion carries 6-0.
Okay. Hardship application, H 2024-0003 for 283 Webster Avenue.
Hi, Eluzer Weiss. Eluzer. Yes. Yes. I'm here I got the officer's decision, which I have a few comments regarding the expenses that we send in. It wasn't counted. A few of the expenses wasn't counted. It was seen most probably.
Mm-hmm.
Then we have for the management fee, the officer wrote that he can't calculate that because it's a own part. We manage it by ourselves. So we asked us to send in a proposal from a third parties, which we did, that we want to amend to the officer's decision. Then we have as per this, on the officer's decision, it says clearly that the violations is not abated. We got an email from Thomas, from the inspector, that all the violations are abated. And I was speaking to Eric again about it, and I don't know why it was missed in the decisions. Then on the calculations from the previous rent rolls, it says not filed, and we did file that, and I got the 2025 rent roll that we received from the rent leveling board, from the rent control board office, and it's not in the decision, correct numbers. So we just want to or amend it, or the calculations about the hardship increase might be the right amount to accept, but it definitely has to be updated, the rental numbers on file.
If we look at the hearing officer's revised report and recommendation, so are you saying, if you have page 3 of 3, which would be page 352 of 372, just so we can understand correctly, are you saying these, the unit designation, the current rent, and after increase are not the right calculations? That was page 352 of 372.
Correct,
page
yes.
3 of 3 of the hearing officers.
Correct.
Okay. So, I'm sorry, if you could, are these incorrect?
Correct.
Oh, so we really can't work with this then?
Correct. It has to be revised. That's one of the reasons that I'm asking. I did send in an email to update that, but most probably it was too busy, the office, and it wasn't updated. So I would like to ask it should be resent to the officer to look it over again, and then make the decision.
That seems reasonable, and if you've abated all the compliance, everything's now in substantial compliance, if you could submit both of those, the new calculation, your substantial compliance that you've abated all the problems, this may not need to come back to us. The office may be able to resolve
Correct.
this.
Just update the numbers and the leftover expenses and the abatement. We can hear from the inspector if that's okay, like if it's abated or not.
I think you would have to hear it again to see what
Yes.
the numbers
Okay,
were.
that's not really relevant. I guess we could remand this back to the office.
Yes, I'm sorry, I didn't understand you, sir. If you have submitted new information to the office,
Correct.
You have. Oh, okay.
I can show the emails if it's.
No, I believe
necessary.
you. I just didn't understand what you were saying. So, if they're saying that there's more information that wasn't included in this revised report, I do think that the best course would be to remand it back to the office and let them review all the new information and issue a current recommendation.
Yep.
Correct. I will accept like the amount is reasonable for the increase. So if the office wants to just update it and not have to come back, I'm okay with that. But
I may have
Okay.
spoken out of turn on that.
huh?
Okay.
But we'll
It's easier
hear
for
it
me
again
just
if we
not to
need
come
to.
back and like.
Yeah, but obviously we need, correct figures, and
Right.
if you've abated any issues,
The abatement of the violation, we can hear that from the
Then-
office from the inspector.
then it may, it would lead us to a different conclusion, because
Correct.
we wouldn't have to do this provisionally.
Right.
Okay,
And we
Mr.
can hear
Watson.
that
That's
from the
all to be
inspector, just-
determined.
Right.
All right, thank you. Motion to close. Oh,
Oh.
you have. No,
Did you want to hit?
you can speak. Come on.
I do. Eric Bowith, Assistant Director, Hearing Officer. You know what I'm spelling, right? Yeah, so just to establish for the record, that not only, substantial compliance aside, we will need some sort of proofs for W Manage LLC. Again, that whether it's a certificate of formation in New Jersey, or if it is articles of organization from New York, something to establish that this is a legitimate entity. Invoices and payments for S&W appliance. However, that again, after review, may again, that might just be a capital improvement. I don't know that that would fall under maintenance and repair. And then the payments for ManageGo.LLC, we just need a little bit more. What were these payments for? Okay. And I just wanted to put that on the record.
Okay.
And thank you again, commissioners. If you have any questions.
No. No
No,
question.
I mean, you're right. If
So-
you
so
have
you-
to review all this material, that's certainly,
If you're willing to allow more supplemented documents, we'll review them. You can remand it back to us. We'll review it. But I just wanted to put on the record exactly what I'm looking for, just so that it's clear.
Okay, that's
Okay.
no problem.
Thank you.
All right. Motion to close the public portion of the meeting.
Second.
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 A motion has been given to close public hearing and it's been seconded. All in favor?
I,
Aye.
Opposed? The motion carries.
All right.
Okay, so now are we looking to set a motion to remand this back to the Bureau?
Yes, we will.
Okay, so someone
We'll make a motion and make a motion that this is remanded back to rent control.
Okay, we have a motion to remand this back to the Bureau. Do I have a second?
Second.
Okay, we're going to vote. In case number H 2024-003, we have a motion to remand this back to the Bureau. Alexander Hamilton,
Yes.
Daniel Hill,
Yes.
James Eacock,
yes.
Mark Isikoff,
Yes.
Michael T. Brown,
Yes.
Sullivan C. Johnson.
Yes.
Motion carries 6-0.
Are there any other cases or anything else out there?
That's it. Just motion to adjourn.
Motion to adjourn.
Second.
The motion has been posed to adjourn. Has been second. All in favor?
Aye.
Passes.
All right.
Good night.